Welcome to the Supreme Grammar Podcast, where you can learn to write like a Supreme Court justice, with me, Jill Barton. On this episode, I've asked our AI host to describe everything legal writers need to know about using colons and semicolons, because lawyers and judges tend to use a lot of them. Let's listen in.
Welcome to the deep dive. Today we're tackling two really useful punctuation marks.
That's right, colons and semicolons. They seem small, but they pack a punch.
Yeah, they really do. We're digging into chapters 3 and 15 of Jill Barton's book, The Supreme Guide to Writing.
It's a great source, especially because it looks at how Supreme Court justices actually write.
Exactly. So our goal today is to help you, maybe you're a law student, a lawyer already, or just someone who wants to write better. Use these marks like a pro.
Make your writing clearer, more modern, more effective. Learning from the best, essentially.
Okay, let's jump into colons first. What's the main job of a colon?
Well, the basic idea, it sort of points ahead. It sets off information that explains or completes what came just before it.
Like saying, okay, pay attention, here comes the important detail.
Pretty much. Often after a full sentence, an independent clause.
But Barton notes the justices are sometimes a bit more flexible, right? They don't always stick to that must follow an independent clause rule.
That's a really interesting point she makes. They might use a colon even after a phrase if it leads directly into, say, a quote or a list or something closely related.
So clarity trumps the strict traditional rule sometimes.
It seems that way. It's about making the connection obvious for the reader, even if it bends the old grammar book definition a little.
Barton even throws in a literary example, James Joyce.
Oh, right. And Ulysses.
Yeah.
Apparently he used loads of them. 15 in one sentence, she says.
Wow. Okay, maybe the justices aren't that extreme.
No, probably not. But it shows the power of the colon to structure thought, create breaks.
And this flexibility, it avoids those sometimes clunky phrases like as follows or the following.
Yeah, often it does. While you do see justices use those phrases sometimes, they also skip them when the colon alone does the job more smoothly. It feels more direct, more modern, maybe.
Makes sense.
Yeah.
Okay, let's get concrete. Barton gives us some examples from actual opinions. How about setting off a summary?
Yep, here's one. As the state summarized, then the colon, he's not psychotic, he's not delusional.
See, that colon just flags the quote perfectly. It's the essence of the state's point.
Instantly clear. Very efficient.
Okay, another use. Introducing a definition. Super important in legal writing.
Absolutely critical.
The example is the ESA defines critical habitat as colon, and then it launches into the full definition.
Right, with parts 1 and 2, laying out the specific areas inside and outside the geographical area, the essential features, all that detail.
The colon acts like a formal introduction to that precise language.
Exactly. No ambiguity about where the definition starts.
What about setting up a caveat, like a warning or a condition?
Yeah, there's an example like, first, however, a caveat, colon. We readily admit that discerning the meaning is tricky.
So it signals, hold on, here's an important qualification.
Precisely. It manages expectations and adds that layer of nuance.
And introducing a contrast.
Like this one.
Yeah.
So too here, colon. Contrary to the court's analysis, Congress's use of any covers defendants.
The so too here sets the stage.
Very useful.
How about expressing a consequence?
Good one. No surprise. Colon. It encourages us to read the former language as allowing, and so on.
The colon links the unsurprising nature to the logical result.
Yeah, it emphasizes that cause and effect relationship.
Explaining a rationale seems like another key use.
Definitely. But the Shelton court had already explained why the failure to narrowly tailor was problematic, colon, because the statute significantly burdened rights.
The why is answered right after the colon.
Directly connects the problem to its underlying reason. Strong, persuasive technique.
And the classic use following a proper independent clause.
Sure, to repeat, that's the clause, colon. The board has broad investigatory powers. Then the list comes.
It can administer oaths, issue subpoenas, take evidence, all those powers laid out.
That's the textbook use, really, expanding on the main statement.
Here's one introducing a clear statement or quote.
Okay.
The court was clear, colon, we cannot say as a constitutional matter. You know, the rest of the quote.
Right. The colon gives the quote that extra emphasis, highlighting its definitiveness.
We also saw an example formulating a rule, even using as follows.
Yeah. Putting all these statutory terms together, the rule can be stated as follows. Colon, a permit is required when.
So even with as follows, the colon still does the heavy lifting of presenting the rule itself.
It provides that essential structural break.
And finally, introducing a really significant or portentous sentence.
The plurality's response is the following portentous sentence, colon, and then that important statement about the treaty negotiations.
It definitely draws your eye to what follows.
For sure. It signals importance.
Okay, one last quick point on colons before we switch gears. Formal salutations.
Yes. In letters or emails.
Barton reminds us, use a colon for formal greetings like Dear Judge Rothenberg.
But a comma for less formal ones like Dear Leslie.
It's a small convention, but it signals the right level of formality.
Absolutely. Shows you know the ropes of professional communication.
All right, shifting focus now, let's talk semicolons.
The often feared, sometimes misunderstood semicolon.
Barton starts with a great quote from Justice Douglas about how legal messages can be identical right down to the commas and semicolons.
It really underscores their importance for precision, doesn't it?
It does. So what are the main jobs of the semicolon, according to Barton and the justices' practice?
Two main things, really. One is separating items in a complicated list or series, especially if those items have internal commas.
Okay, that makes sense. To avoid confusion.
And the other main use is sometimes connecting two closely related sentences, two independent clauses.
Before we dive deeper, we have to mention Kurt Vonnegut.
Ah, yes, the famous semicolon hater. All they do is show you've been to college.
Right. But Barton points out, well, the justices have been to college, and they find semicolons pretty useful.
They definitely disregard Vonnegut's advice there. The semicolon is sort of this useful middle ground. It connects ideas more strongly than a comma.
But it's less final than a period. A less abrupt stop.
Exactly. It provides clarity, especially in complex writing. Barton mentions its history tracing back to Venice, this need for more nuance. But she also cautions against just stringing sentences together endlessly with them.
Good advice. So let's focus on that first use. Complex series. When lists get complicated.
This is where semicolons really shine. If the items in your list are long clauses or have commas inside them, using only commas to separate the main items would be a nightmare to read.
Barton gives an example from Chief Justice Roberts. It's a long sentence about justiciability.
Oh yeah, it lists several points.
Here's another from Justice Sotomayor about private enforcement suits.
Similar structure, listing key points missing from an opinion.
Again, the semicolons separate these complex ideas cleanly.
And she even uses them with a numbered list sometimes for extra clarity, like defining defense preclusion.
Right. 1, a previous action. Then 2, the previous action. 3, the defense was asserted. And 4, the district court concludes.
The combo of numbers and semicolons makes that definition incredibly structured and easy to follow.
Okay, what about the other main use? Connecting two closely related sentences.
Right, joining two independent clauses without a conjunction like and or but. It suggests a really close link between the two ideas.
Barton notes the justices use this, but maybe not all the time. Shorter sentences are often preferred.
Yeah, it seems they use it more sparingly. It can create a nice flow, but sometimes two shorter sentences are just punchier.
We have examples like, an ambulance struggled to reach the victim. Police had trouble responding.
See how it links those two related difficulties smoothly?
Okay, what about using semicolons with those longer connecting words, conjunctive adverbs?
Words like however, therefore, instead, consequently.
Yeah. Barton says the rule is semicolon before the adverb, comma after it when joining sentences.
That's the standard rule. Though again, she observes the justices don't use this structure that often. Maybe they prefer a simpler but or just starting new sentence. So the structure exists even if it's not their most common way to connect ideas.
Got it. Now, the last big area, and maybe the most common one in legal writing, string citations.
Oh yeah. If you read any court opinion, you see these everywhere.
Semicolons are absolutely essential here.
Completely essential. You're listing multiple cases or statutes or other authorities together. The semicolon is what separates one citation from the next.
And the rule is generally newest and highest authorities first.
That's the standard Blue Book convention.
Yeah.
Helps the reader prioritize.
Barton gives really long examples citing a whole bunch of cases about abortion providers invoking patient rights.
Exactly. Just listing them out, semicolon after semicolon. It's the only way to keep such a dense list readable.
So mastering semicolons for string cites is non-negotiable for legal writers.
Absolutely non-negotiable. It's fundamental.
So wrapping this up, it seems like both colons and semicolons, they might look like minor details, but they really aren't.
Not at all. They're tools for clarity, for structure, for adding sophistication. Mastering them, like the justices do, really elevates your writing.
It helps you become a clearer, more effective, and definitely a more modern writer.
That's the goal.
So we really encourage you listening, take these ideas, these examples from Barton's guide and the justice's own writing, and start consciously applying them.
Yeah, notice where a colon might help you introduce something, or where a semicolon could clear up a complex list or link ideas smoothly. Pay attention to the effect.
Which leads us to a final thought for you to consider.
How can making these seemingly small punctuation choices, deciding between a comma, a colon, a semicolon, or a period, do more than just fix grammar?
How can it actually change the rhythm, the emphasis, and ultimately the persuasive power of your writing, especially when the stakes are high, like in a legal argument? Think about how these little marks shape the reader's journey through your ideas.
So when used well, colons and semicolons add order to legal writing by breaking up complex ideas. Tune into our next Supreme Grammar episode about commas, and potentially avoiding a multi-million-dollar comma mistake. And remember, you can be a great legal writer.